When she tried to grab the phone, I yanked back, and when I yanked back, she pulled at the same time. And my grip is a little stronger because I'm a man. She fell backwards and hit her head.
When a 911 dispatcher picked up the line that night, the first sound they heard was a woman's terrified voice, then a man's shout, then a loud crack, and then nothing but dead air. So the call had been disconnected, the phone shattered, and the line meant to save her life had been ripped away. For the next several minutes, the dispatcher had no way of knowing if the woman on the other end was still breathing, and that question hung in the silence like smoke, unanswered. So while police units raced toward an address they could only hope was still the right one. What they found when they arrived would launch a case that tested everything we think we know about the difference between a heated argument and a calculated attempt to isolate a victim from the entire world. The suspect in this case stood before Judge Patricia Boyd in a Fair County courtroom, charged with assault family violence, and from the very first moments of the hearing, the tension in the room was unmistakable. The plea agreement had already been laid out. The PSI, or pre-sentence investigation, had been waived, meaning both sides had agreed to move forward without a deep dive background report into the defendant's history. The punishment was capped at 6 years in prison, and the state was remaining silent on the application, which in courtroom language meant the prosecution was not actively arguing for the maximum sentence. On the surface, this looked like a routine plea hearing, the kind of procedural moment that happens thousands of times a day in courthouses across America, but the details that began to emerge from the police report told a very different story.
All right. In this case, the PSI was waived.
Yeah.
And according to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. The state is silent on your application. They're taking in consideration 2026 CR 005411 and 2026 AL 001917.
The defendant began to explain his version of events, and that is where the first cracks in the narrative appeared.
Well, basically the whole situation was feeling that she was stepping out on me at the time.
Sorry, what?
I thought she was stepping out on me at the time. So what I did was I entered the apartment, grabbed her phone, looked through it, found out that she was talking to said witness in the statement, and a few other people. I went outside when I was looking at the phone. I tossed the phone on the ground, broke it, was coming back to get it to her, but she was on another phone. So I went around the building, snuck behind her, grabbed another phone. She tried to grab me. So I pushed her hand away from me and slapped another phone on the ground and basically drove away after that. When they, tried to get me or, pull me over.
He told the court that the entire situation started because he believed the victim, the mother of his child, and the woman he had lived with for years, was stepping out on him. He said he got her phone, looked through it, and found messages from another man. That discovery, he explained, made him upset, so he went outside, tossed the phone on the ground, and broke it. But then, according to his own words, he saw her on another phone, so he went around the building, snuck behind her, and grabbed that one too. He said she tried to grab him, so he pushed her hand away. He insisted there was no punching, no strangulation, no hurting, no shoving. He said her head hit the tree because she fell backward when he yanked the phone away, and the only reason she lost her balance, in his own admission, was because his grip was stronger since he was a man. Think about that logic for a moment, because it is one of the most honest and unintentionally damning things a defendant has ever said in open court. Now here is where the pattern completely shifts, because the stipulations read aloud by Judge Boyd painted a picture so different from the defendant's account that it felt like two separate incidents were being described.
So how did he get into the apartment? I read the stipulations, but it says that, according to the stipulations, that he climbed onto the second floor patio balcony.
So I climbed to the second floor patio balcony to knock on the window because she wasn't letting me in because she took my key when I went to work a few nights before, because I decided to stay, over my mother's house one night to let everything calm down because she was upset at me for whatever reason. You know what I'm saying? I guess she said she was having stress, she was PMSing or whatever having to go through. But I decided to come back and I seen that my key wasn't on the key ring. So that's the reason why I climbed on the balcony. That's the reason why I walked up the stairs and then the door was already open. That's the reason why there was no forced entry and the burglary habitation had got to be dismissed.
All right, according to the stipulations, it states, victim stated the incident began as she was dozing off in her room after putting her children to bed. She stated she suddenly heard rocks being thrown at her patio window door. So the patio window door, according to the stipulations, that's a second floor balcony. Doesn't mention you knocking on the front door. It says victim walked toward the living room to see what was happening. Victim stated she observed the suspect from inside the apartment attempting to burglarize her residence. Victim stated suspect climbed onto the second floor patio balcony. Victim stated she immediately called 911 to report the incident. Victim stated dispatchers advised her to exit through the front door with her children. Victim stated that when she unlocked the front door, suspect kicked the door open and entered the residence. Victim stated she was pushed by the suspect. Suspect took victim's cellular phone, disconnected the 911 call, and broke the device, shattering the screen. Victim stated suspect then ran downstairs with her phone. Victim ran outside and located the suspect. Victim stated suspect tackled her to the ground, causing her to strike her head against a tree. Victim had her son's phone to call 911 again. However, suspect broke the second phone, preventing her from contacting emergency services. And then it states, witness, the downstairs neighbor, stated he was in his room when he heard a disturbance outside. Witness stated he looked out of his window and observed the suspect on top of victim, possibly strangling her and restricting her movement.
Possibly.
Witness stated victim managed to get away. However, he then observed suspect.
According to the victim's statement, she had just put her children to bed and was dozing off in her room when she suddenly heard rocks being thrown at her second floor patio door. She walked toward the living room and saw the suspect from inside the apartment attempting to climb onto the second floor balcony. She immediately called 911 to report the incident. The dispatcher advised her to exit through the front door with her children. But when she unlocked the front door, the suspect kicked the door open and entered the residence. He pushed her. He took her cellular phone. He disconnected the 911 call, and then he broke the device, shattering the screen. That single act, breaking a phone during an active 911 call, is a federal crime under certain circumstances because it constitutes intentional interference with emergency communications, and it is one of the most serious red flags a court can see because it demonstrates a deliberate effort to cut off a victim's access to help. The victim's statement continued, and the details grew worse. The suspect ran downstairs with her phone. She ran outside and located him. The suspect then tackled her to the ground, causing her to strike her head against a tree. She had her son's phone to call 911 again, but the suspect broke the second phone, preventing her from contacting emergency services. A downstairs neighbor, an independent witness with no stake in the relationship, stated he looked out his window and observed the suspect on top of the victim, possibly strangling her and restricting her movement. The witness then observed the suspect striking her before he fled the scene. A stranger looked out his window and saw a woman being held down, possibly choked, definitely struck, and then he watched the attacker run. That witness statement alone shattered the defendant's claim that nothing happened beyond a push of the hand.
Like I said, sir, there was no, I did not punch her, I did not hit her, I did not strike her. I pushed her hand off me when she tried to grab the phone out of my hand because she tried to grab me.
Gotcha. Okay, so if there's a neighbor that says he saw you punch her in the head, he'd be wrong?
He'd be wrong.
He'd be wrong. All right.
Yes, he would be.
The defendant's response to the neighbor's account was immediate and revealing. He did not pause to reflect. He did not express confusion. He simply said the neighbor would be wrong. So the neighbor would be wrong about the punching. The neighbor would be wrong about the strangulation. But he was right about everything else. This is the kind of credibility test that judges and juries face constantly, where one party asks you to believe that every witness, every piece of physical evidence, and every inconsistency in their own story is a coincidence, while the other side's account remains consistent from the first 911 call to the final police report. What makes this case stick with you long after the video ends is not just the violence, it is the psychology behind breaking those phones. Think about how completely dependent we all are on our devices to reach help in an emergency. If you have ever been in a situation where your phone battery died while you were lost, or you dropped your phone and cracked the screen and felt that moment of panic because you were suddenly cut off, you understand a fraction of what that victim felt. Now imagine that isolation was not an accident, but was done to you intentionally by someone who claimed to love you. That is the difference between bad luck and abuse, and the law treats those two things very differently. Judge Boyd, who has spent years on the bench and has seen every version of this story play out, began asking pointed questions about how the defendant actually got into the apartment. The stipulation stated he climbed onto the second floor balcony, and the victim said he kicked the door open when she unlocked it. The defendant claimed the door was already open and that a prior burglary charge had been dismissed because there was no forced entry. But Judge Boyd was not asking about dismissed charges. She was asking about what happened that night, and the distinction matters because in family violence cases, the method of entry often reveals intent. A person who climbs a balcony and kicks open a door is not there to have a conversation.
So I climbed to the second floor patio balcony to knock on the window because she wasn't letting me in because she took my key when I went to work a few nights before, because I decided to stay, over my mother's house one night to let everything calm down because she was upset at me for whatever reason. You know what I'm saying? I guess she said she was having stress, she was PMSing or whatever happened to her. But I decided to come back and I seen that my key wasn't on the key ring. So that's the reason why I climbed on the balcony. That's the reason why I walked up the stairs and then the door was already open. That's the reason why there was no forced entry and the burglary habitation had gotten dismissed.
All right, according to the stipulations, it states, victim stated the incident began as she was dozing off in her room after putting her children to bed. She stated she suddenly heard rocks being thrown at her patio window door. So the patio window door, according to the stipulations, that's a second floor balcony. Doesn't mention you knocking on the front door. It says victim walked toward the living room to see what was happening. Victim stated she observed the suspect from inside the apartment attempting to burglarize her residence. Victim stated suspect climbed onto the second floor patio balcony. Victim stated she immediately called 911 to report the incident. Victim stated dispatchers advised her to exit through the front door with her children. Victim stated that when she unlocked the front door, suspect kicked the door open and entered the residence.
They are there to control, to confront, and to make sure no one else can intervene. The prosecutor then asked a series of questions that exposed the core of the case.
All right. And you were talking about the facts earlier, so let's talk about that if you don't mind, please. So you went to her location, correct?
This our location. We both live there, but yes, sir.
All right. She didn't give you permission to go there that night, right?
I mean, my ID has the same address as hers right there. So, I mean, I already asked the police officers multiple times beforehand. They said I have authority to be there.
But did she invite you over that night?
No, she didn't invite me over a few nights.
You went on your own relation because you felt you had the authority to be, like you
Yes.
just said.
Yeah.
All right. And you were outside throwing rocks at her window, right?
Yes.
Trying to get her attention, I guess?
Yes, I was.
All right. And after you got her attention, she went to the front door, right?
Yes, I did.
And then you entered through the front door after she opened the door, right?
Yes.
But she didn't invite you in, right? You just went in.
Like I said, my ID has the same address as.
I understand, but she didn't invite you in, right?
Regardless, I talked to the police officers and they told me I can enter there anytime I would like.
Right, so if she didn't invite you in, you just went in because you felt you had the authority to be there and you grabbed her phone. Not your phone,
Yes, I did.
just her phone. You ran outside with that phone then, right?
Yes, sir.
All right. She chased after you, right?
I don't know if she did or she didn't.
She did. Where'd she go?
I didn't know where she went after that. I just turned around and started looking through the phone.
Okay, turn around, looking through the phone, because that's what was most important to you, is wanting to know if she's talking to this person, right?
Yes.
Okay. Get outside eventually, right?
Yes, sir.
The defendant admitted he went to the location on his own. He admitted the victim did not invite him over that night. He admitted he threw rocks at her window. He admitted he grabbed her phone, ran outside with it, and when asked if the most important thing to him in that moment was finding out if she was talking to someone else, he said yes. Then came the question that every viewer needs to hear and remember. The prosecutor asked if the whole purpose of everything he did was finding out that information regardless of how he did it, and the defendant answered in a sense yes.
One last one, if I may. So you mentioned just right now that you found out what you wanted on the phone, then, right?
Mhm.
The whole purpose of you was to find out. That's all that mattered to you, was finding out the information, right?
Yes, sir.
That single admission transformed the entire hearing because it established motive and intent in the defendant's own words. He was not defending himself. He was not reacting to a threat. He was conducting an investigation of his own making, and he was willing to break phones, push past doors, and leave a woman on the ground next to a tree to complete it. Here is a question that you will probably have a strong opinion on, and I genuinely want you to answer it in the comments. When a defendant admits that their primary goal was to get information, and they admit they did not care how they got it should the legal system treat that as a crime of passion, which often receives more leniency, or as a crime of calculated control, which should receive less. The line between the two is blurrier than most people realize, and your answer might depend on whether you have ever been in a relationship where trust was broken and you felt that rush of desperate certainty that you needed to know the truth at any cost. The defense attorney argued that this was a 10-year relationship with ups and downs, that jealousy is a human emotion, and that the defendant now understood the relationship needed to end. He asked the court to let the defendant have a relationship with his children and move on.
Unfortunately, in relationships, there are ups and downs, and it sounds like this couple had a tenuous 10-year relationship back and forth. There were allegations of him, being not, I don't want to use, loyal to the other partner and talking to other individuals and stuff. And jealousy is a bad thing to have, but it happens. We're human. So, Judge, I think he understands that the relationship with this woman should be over. He should not be near her anymore. Let him have his children by her. Let him be have a relationship with those children and not her.
And then the defendant added a comment that made the entire courtroom pause. He said he was tired of people saying he was taking care of a child that was not his, even though minutes earlier he had proudly told the court he claimed the victim's child as his own. Judge Boyd caught the contradiction immediately and asked why he felt the need to keep emphasizing that the child was not biologically his. The defendant tried to explain, but the damage was done because the court had just witnessed someone use a child as both a badge of honor and a weapon, depending on which moment served him better.
Yeah.
All right, why do people always say that I'm taking care of a child that's not mine? You've given me testimony and you said that child is like your own son. Why the need to keep saying that he's not even mine?
Biologically, because there's a protective order that's on me right now that I had to alter for 2 years with a civil.
How old is the child you have with her?
9. That states that I can't be around.
Wait a
her.
minute. So you have a child with her who's 9 years old, right? Is that the only child you have?
That's biologically by her. Yes.
No. In the world, is that the only child you have?
Oh, in the world, no.
Okay, so you have a 9-year-old, and that's with the complainant. How old is your other child?
My other child in California, he's about like 6, about 7.
6 years old. Any other children?
I claim him as my own. So yes, the other child, 6-year-old, one that's not biologically mine, but yes, I still claim he's mine.
All right, there appears to maybe have been some overlapping if you have a 6-year-old in California.
Well, I had to leave. I left her because of what happened in 2019. I had left, it was like an on and off relationship. She was trying to play around and she had started talking to other people and going out and stuff like that. So I had moved to California. When I had moved to California, she was calling me often, telling me that she still missed me and she wanted me to come back. I took a Greyhound to come back that she paid for me to come back. Otherwise, I wouldn't even be back here. Just to let you know.
All right.
The court then delivered its sentence. Judge Boyd found the defendant guilty, took into consideration 2 other pending cases that painted a pattern of behavior, and made an affirmative finding of family violence. That affirmative finding is legally significant because it triggers federal firearm disabilities, meaning the defendant can never legally own or possess a weapon or ammunition again. The court sentenced him to 3 years in prison with a $1,500 fine, time and money to run concurrently with the other cases, and imposed a no-contact order with the victim. Because it was a plea bargain agreement, the defendant had waived his right to appeal, and Judge Boyd made sure he understood that the decision was final.
All right. Thank you. And thank you for giving me some insight. This is what the court is going to do. The court is going to find you guilty, take into consideration 2026 CR 005411 and 2026 AL 001917. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's a $1,500 fine, time and money to run concurrently. The court will sentence you to 3 years. The court will retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction.
There is a strange satisfaction in watching a system work exactly as it should, but there is also a quiet frustration that lingers. 3 years for a crime that involved climbing a balcony, kicking open a door, breaking 2 phones during active 911 calls, tackling a woman to the ground, and being witnessed by a neighbor striking her and possibly strangling her, that sentence feels like it fits the legal framework but falls short of full justice. And that is the part of these cases that stays with you, the gap between what the law allows and what the facts demand. The lesson here is deceptively simple and brutally hard to apply. The moment someone tries to isolate you from the outside world, whether by breaking your phone, controlling who you talk to, or making you feel like no one else will believe you, that is not love. That is a crime in progress, and the law has a name for it. If you walk away from this video remembering only one thing, remember that the broken phone was not a side detail. It was the entire point. It was the act that turned a domestic dispute into a felony, and it is the reason the defendant walked out of that courtroom in handcuffs instead of on probation. If this case resonated with you, drop a comment with the name of a courtroom interaction or legal topic you want me to break down next. And while you are here, subscribe and share this video to help build a more informed society that actually understands how the justice system works when the cameras are rolling and when they are not.